Matter before the court is York 23-154. Is it Dahlem? Is that correct? Versus the City of Saco et al. And we are being recorded both video and audio and streamed live on the web today. If counsel are ready, I would ask the counsel who are arguing to approach the podium and introduce themselves for the record. First for the appellant.
Your Honor, Timothy Murphy for the City of Saco.
Thank you.
Good afternoon, Your Honors. Jana, Kenney for Appellants Amarajit, Singh, Dhillon, and Ajinder, Kaur.
Thank you.
And Keith Richard, along with Richard Quayle of Archipelago for the Appellee, Michael Dahlem.
Thank you. Then, excuse me, Mr. Murphy, if you're ready, then we'd be happy to hear your argument in this matter. And I understand appellants are splitting the time.
That's correct, Your Honor. And may it please the court, my name is Timothy Murphy. I'm here on behalf of the City of Saco. And I would like to frame what we think is the key argument for the court today by directing your attention to one of your own cases, which is the Lucarelli versus City of South Portland case. And I'd like to quote just a couple of sentences from that decision. You wrote, "To establish standing to appeal a decision of a zoning board, the party must have participated in the hearing. One does not participate in a hearing by expressing opposition to an application prior to the hearing." And I want to stress that, prior to the hearing. And lastly, you wrote, "The requirement of participation is so well established that we have recently held," and this is in the Otis case, "that even the Attorney General must participate in the hearing to establish standing." So well established. Participation. You have to participate below. On 4 separate occasions, Mr. Dahlem had opportunity to engage. He had opportunity to participate in proceedings at the lower level. In June of 2021, before the main DEP, in August and September, before the Saco City Council, and in October of 2021, before the Saco Planning Board, Mr. Dahlem had opportunity to be a man in the arena, to fight the good fight, to participate. He didn't. He was a no-show. These were the chances he had, and instead, we have a 15-count complaint, a 15-page complaint with 6 counts.
Counsel, I see that the green light is on. This requirement for participation below, isn't that in the context of an appeal or a petition for review? And count 6, the petition for review in this case was dismissed?
The ADB count was dismissed, Your Honor, and we believe that all the counts were subject to ADB proceeding. The case law seems to say that ADB is the exclusive remedy. If your harms can be corrected through an ADB remedy, you don't need these other mechanisms of relief. That's the Kaur decision, if I understand it correctly.
This is a zoning, it's a legislative act, correct?
No, Your Honor, I don't believe it's a legislative act.
You don't think zoning is a legislative act?
Zoning is a legislative act. But in this matter, the legislative act occurred in 2017 when the City Council enacted contract zoning. Fast forward 2 years, and we're looking at how do you handle an existing contract zone agreement? We were amending.
Well, it's not the agreement, it's the amendment to the zoning act. So why isn't an amendment to a legislative act a legislative act?
Because we weren't amending the legislative act. We were amending a contract between 2 parties.
Well, the original contract, though, amended the zoning ordinance, correct?
That's correct, Your Honor.
Okay. And so your position is that the 2017 contract zone agreement somehow survives its own terms. In other words, the terms that say it's null and void if certain actions aren't taken. Your argument is that null and void doesn't mean null and void. It means
It means-
something else.
That's correct, Your Honor.
What do you think it means?
It means voidable.
It
So,
doesn't say voidable. It says null and void.
no, yes, that's correct. But the court below, turning to Black's, used the definition that null means void. But if you read through Black's, it later says the more traditional meaning, well, let me quote it, rather than, the word void in its strictest sense does mean of no force and effect. We'll agree, that's what the Superior Court found. But Black's goes on to say, frequently, the word is used and construed as having the more liberal meaning of voidable. Because it's a contract term between parties, the city of Saco had the option to say, it's not null and void.
Why did the city of Saco put these time limits in if it didn't mean to enforce them, or it didn't have any meaning?
I think like most time limits, they're used to encourage the parties to move forward with their application process, to set about to accomplish the goal of their permit. But I'd note.
So they're just aspirational goals? You know,
No, they're not.
Try to do this, and if you don't do it well, we'll just kind of keep
No,
rolling
they're not
along.
aspirational. They're a way of keeping the parties' feet to the fire, Your Honor.
And if they don't keep their feet to the fire,
Then we had the option to say, sorry, the door is closed, you can't build.
so you're saying that the town had the prerogative in the event of failure to comply to either say, no, it continues, it has that unilateral prerogative?
It did, Your Honor, and I'd point to the contract itself, which has an extension clause built within it. Section J, the Driscolls.
For 1 year,
Pardon?
for 1 year.
For 1 year. But that was a unilateral right the Driscolls had.
Did they exercise that right?
No. So really what we're looking at is a failure of the Driscolls to exercise their ability to extend the agreement. We wish they had, but they didn't. And so we think the Superior Court below, while we well understand the traditional interpretation of null meaning it ends, we don't believe this was a sunset clause. One, because the language of the contract allowed for its extension, and two, because we think the law in Maine.
Well, if it wasn't a sunset clause, you don't have to have, if it's nothing more than what you're saying, you don't even need a provision that allows for an extension, because apparently it wouldn't have ended anyway until some party decided to end it.
It's a contract like any other contract, Your Honor. The fact that
Well,
the
either
city
it
of...
ended or it didn't.
I'm sorry?
Either it ended or it didn't after 2 years.
And we've argued consistently that it hasn't, that we were amending.
And so it was in effect forever?
No, it's not. It's in effect if the city agrees to negotiate with the breaching party. However, we could have also said, we're sorry, for policy reasons, we're not going to amend. It was an option we had and reserved. Thank you.
Attorney Kenney?
Chief Justice, Your Honors, may it please the court. The threshold issue in this case is grounded in contract law. Today, appellants ask that this court find the trial court erred.
Is it grounded in contract law? I know it's called contract zoning, but as Justice Connor says, contract zoning is a legislative act.
It's a legislative act but it is still, if you get down to boil it down, it's a contract between two parties. We have a municipality who signed this agreement. We have the Driscolls who signed the agreement. There's an offer, there's consideration, it's a contract. It's a contract zone agreement.
But if the initial entry into the contract zone agreement is a legislative act, why isn't changing the terms of it equally a legislative act?
Your Honors, I think amending a contract zone agreement is a legislative act. But as part of our argument today, even if this court finds that it was the 2021 act by the city of Saco was legislative, the trial court erred in finding that it expired in the first place. So anything that happened in 2021 would have been governed by the comprehensive plan.
But if you accept that the 2021 amendment is a legislative act, then why does the earlier one matter? Because now we have a new act.
Your Honor, I'm asking for the court to conceptualize it as if it's a contract. It's a contract zone agreement. We have a contract that two parties entered in 2017.
Contract zoning is a process by which a town rezones. That's the statute. And then there's case law, Crispin, where we said it's not adjudicatory, it's not quasi-adjudicatory, it's legislative. It's like any other law, isn't it?
Your Honor, it is legislative, but the terms in that contract zone agreement still matter. And the terms and provision, Section 2J, say that the Driscolls only had to seek a building permit.
Well, and they didn't, did they?
They did. It's our contention that
Did
that
they ever
did.
file an application for a building permit?
There were preliminary steps, Your Honor, that
Did they
had.
take any steps with the town to obtain a building permit?
They took steps with DEP, and if you look to the town's requirements to obtain a building permit, those DEP applications and permits, they need to be in place before you can even apply for that permit. And the Driscolls did take steps to secure a sand dune alteration permit in 2018. They applied, they received a permit by rule, they received a survey that was going to be submitted along with that application. So if you actually look at the terms of the contract zone agreement, it says they had to seek a building permit, as opposed to subsection 2H, which says they have to secure a site survey, a survey plan.
Counsel, do you agree that if we concluded that the 2017 contract zone agreement expired, that the 2021 contract zone agreement would be subject to the laws in place at that time?
Your Honor, if you find that the City of Saco's 2021 action created an entirely new contract zone agreement, then yes, that contract zone agreement would have to comply with the comp plan in place in 2021. But we're asking the court to use its de novo review to really look at the language in the contract zone agreement and to compare the language between Section 2J in 2017 as opposed to the same language and that was changed in 2021, where they changed seek to secure, where they changed this broad deadline that they have to seek within 2 years to, you have to secure this building permit by X date. So that goes to the intent of the parties here, and as my colleague here stated, the city is trying to get the applicants to take steps to move them forward in this process with this contract zone agreement, and that, in our view, is why Section 2J provides that they have to seek a permit, right? Because this is a cooperative process in applying for a permit between both the applicant and the city.
Can I ask you whether the state's mandatory shoreland zoning statute preempts the ordinance here?
No, Your Honor, not if we're looking at the laws then in effect in 2017.
Oh, okay, but let's go to 21. It would in that case.
Well, to Justice Douglas' point, if we're creating a new contract zone agreement in 2021, I think we would concede that we would have to comply with that law, yes.
All right, thank you.
So seeking means what? Taking a step? I pick up the phone and I call the DEP and I say, can you send me a packet of information? And then I wait 3 years before I do anything. Is that sufficient?
That's a difficult question, Your Honor. I think seeking does mean to take a step. And whether that initial call suffices, I think under our definition, if you're taking the call and you receive the packet, but to seek, you actually, I think it's very clear from the stipulated record that the Driscolls actually applied for this, it was the sand dune alteration permit. They actually received the initial permit by rule. And that's sorry, Your Honors, I'll wait for my rebuttal. Thank you.
Okay, thank you. Richard?
Thank you, Madam Chief Justice. May it please the court. This case appears at first blush, given all of the claims and the arguments and issues raised, to be rather complex. But I think that the whole controversy really just turns upon this. Why wouldn't law apply to the 2021 City Council decision at issue? And although not argued directly by appellants, their position appears to be that there is not meaningful judicial review of that decision, that this is a discretionary decision regarding a contract between parties, that it's something other than the action that would be legislative. But I think as the court has been pinpointing during the questioning we've heard today, contracts that affect zoning are different. They're not like other municipal contracts. This isn't a snow plowing contract. The legislature has delegated home rule authority to municipalities to enact ordinances, to zone, to enter into contract zone agreements, provided that those enactments don't conflict or frustrate a purpose of state law. Here, the appellants concede that this contract zone agreement enacted in 2021 violates state law and specifically mandatory shoreline zoning. So whatever the outer limits of municipal authority to enter contracts, in these circumstances, that discretion is at its weakest, and the need for judicial review should be the most robust. I'm ready for questions.
In this case, you agree that there's no timely petition for review from the action of the city council, correct? Or the, whatever it was that did this contract zone?
The declaratory judgment counts are timely from the city council action.
But the appeal would be timely only from the planning board.
Correct, so the 30 days, the clocks.
But you're really not pressing any issues with regard to what actions of the planning board. You really are only talking about the actions of the city council, right?
That's correct, Chief Justice. If the
So
city
that's a
council
bit of a
action-
red herring, isn't it, to talk about whether or not it's a timely ADB from the planning board?
That's correct, and Rule 80B doesn't apply to declaratory judgment actions that challenge a contract.
Does it
zone.
matter whether the contract had actually become null and void and no longer existed, so that the action in 2021 was a new CZA, or is it sufficient that it was changing the terms of an old contract zone agreement such that it still is a legislative act?
I would agree with the latter point, Chief Justice, because I think the difference between whether it's a brand-new contract zoning agreement or merely an amendment of the prior one doesn't materially change the fact that the law that is in effect at the time the municipality acts applies.
Well, is this a kind of a grandfathering argument that they're making? That since they had acted in good faith, taken substantial steps under the pre-existing legislated zone, that we should read the actions under the new zone as they shouldn't have the new rules apply?
Yes, Your Honor, so if in effect the 2017 approval is good forever, no matter what the change in law, and we have no opportunity to seek judicial review because our appeal is not timely. That can't be the law.
Well, I mean, you could seek judicial review, but what they're saying is that they should be grandfathered so that they don't have to, the preemption rules, the resource protection doesn't apply to them. They were acting in good faith. They did everything they were supposed to under the earlier version of the law. So the amendment doesn't strip them of the ability to cite the law that was in place at that time. It's kind of a grandfathering vested rights argument, isn't it?
Even if we applied the law that was in effect in 2017, it's still preempted by the Mandatory Shoreline Zoning Act, and the ordinance in 2017 still said, City of Saco, you can't have contract zones in the Resource Protection District. And this property was zoned in the Resource Protection District at that time.
So it was in violation, the 2017 CZA is in violation of the shoreline zone?
Yes, and we're not, see, we are not arguing about the 2017 CZA because our position throughout has been that because it's null and void and was no longer in effect, the 2021 action, it doesn't consider what the 2017 enactment said. We're only looking at the 2021 action, and that's what's at issue in the litigation.
Right, but I just wanted to be clear. I thought I heard you say something different. So is the 2017 CZA subject to the same preemptive effect of the shoreline zone as the 2021 CZA is?
It would be.
Are you talking about setbacks, the setback requirements?
So the Mandatory Shoreline Zoning Act was in effect in 2017, and there was a separate requirement for municipalities to submit their ordinances that govern shoreland areas to the Board of Environmental Protection. I've raised the argument. They've never said that they did. So
I just wasn't clear. Was your argument that it doesn't make any difference because municipalities can't override or can't use a CZA to override the shoreline zoning ordinance, or about the setback requirements, or both?
It would be, the Shoreline Zoning Act would preempt the setback and the lot coverage and the shore frontage that this contract zone created. The relaxation is the same in the 2017 and the 2021
Okay.
contract zone.
So in a sense, you're saying that the 217 one was void because it was preempted?
It would have been, but because the city took this action in 2021, they reopened the opportunity to challenge it and seek judicial review. And we
Well, it's a
filed.
deck action, so it wouldn't have had the same time limit, so you could have opposed it even under the 217, right?
In
Is
theory,
it
Your
more that
Honor,
it's moot because your position is it's expired anyway, so it doesn't matter?
it's a 6 or 2 3s, in other words.
But when we talk about void versus voidable, if it's preempted, it's void for that reason, too.
It would be.
In other words,
Or
if they
it's
satisfied all the 2017 requirements, did it all to a T, still no good because it's preempted.
So, and yes, and then maybe we'd be subject to the general 6-year
Okay,
statute of
all right.
limitations. Right?
Be void ab initio?
No, Your Honor, because void ab initio would mean that on November 20th, 2017, it was void. What has happened is the passage of time and the expiration of that 2-year deadline had the result that from that moment, the 2-year deadline being hit without seeking extension, then it became null and void.
But on November 20, 2017, the standards in the Shoreland Zoning Act were in place,
Right.
and this agreement didn't comply with those
Right.
standards.
So it would be preempted, but in terms of contract principles of void, I don't.
Okay.
So you're saying either way you win? We
You're free
hear
to say
a common
no, no,
argument
no.
we hear.
It doesn't matter on what grounds.
Okay.
The result is the same.
With respect to your cross appeal, are you pressing the Rule 80B appeal?
No, it wasn't with respect to count 6, Your Honor. It was with respect to count 1 and the raised judicata count, because this property has been a consideration in the city of Saco since 2009, and there was a prior appeal from a variance that was denied for the property to split it into the 2 lots along the lines of what the contract zone eventually did. Our argument on raised judicata was both with respect to the fact that this is just 1 lot and that has been permanently and irreversibly merged.
But isn't that the whole point of the contract zoning, is they're sort of accepting that and saying, but legislatively, by doing a contract zone agreement, we're going to change that?
Right, so the question would be, does the contract zone supersede what would otherwise be the effect of the merger ordinance?
Isn't that the whole point of it?
That's part of it, Your Honor, I would agree.
But you don't want any change in the judgment, correct? So did you really have to file a cross appeal?
I probably did not, but I wanted to preserve all the arguments that we could. The standing issues have been continuously challenged, so we did also file a motion to reconsider raising some of the issues around the fact that there was no public hearing that was held. So the fact that.
The standing issue only really comes up if we do this, it's treated as an 80B, right?
Right, if you treat it, if you change the law on contract zones and say, now we're going to subject them to Rule 80B requirements, Rule 80B does have a
The
participation
participation
requirement.
piece for standing. But otherwise, there doesn't seem to be any dispute that your clients meet, as the people across the street, the traditional notions of the particularized injury in order to meet standing requirements.
Exactly, and that hasn't been challenged.
And it does raise the interesting question that we don't have to answer in this case, but the test for having to file a cross appeal is whether you want to change the judgment at all. And usually when there's a damage issue or something like that, it's pretty clear. It's not so clear when you have a declaratory judgment action, where you may not agree with some of the findings of the declaratory judgment. So when you have you don't agree with all the findings, but the bottom line is you win. Whether you have to find a cross appeal or not is an interesting question in the declaratory judgment context, and it sounds like you were prudent in filing a cross appeal on that ground.
Belt and suspenders. But ultimately, judgment affirm and the relief being that any permits sought pursuant to this contract zone agreement are no good. That's what we're seeking, is that the relief would be the same under any of the count theories.
There don't appear to be additional questions.
Thank you.
And Ms. Kenney, I believe you reserved 2 minutes for rebuttal.
And even though it's rebuttal, can you address the issue, his argument that even if we were under the 2017, it's still preempted?
Yes, Your Honor. I guess my only point to that, as I was sitting there thinking about it, was that the trial court's order, I believe, explicitly said that they were only finding on count 4 the preemption under the 2021 contract zone is preempted by state mandatory shoreline zoning act. I guess I personally don't have knowledge on when that went into effect and what was in place in 2017. So I guess my only point to that would be that our argument is still essentially that we are grandfathered to whatever laws, whether that's the comprehensive plan in the city of Saco, state law, or other zoning ordinances that were then in effect in 2017.
Well, on the comprehensive plan issue, in order to make this final, you dropped your comprehensive plan count. So doesn't that mean you've waived any argument as to whether there's inconsistency with the comprehensive plan or consistency? Doesn't that, you've agreed we're not going to talk about that?
The only point to that is that contract zone agreements have to comply with the city's comprehensive plan, and my only point is that that under the 2017 contract zone agreement, the city was complying with the comp plan then in effect. If there are no further questions, Your Honor, thank you for your time.
Thank you. Thank you, counsel. With that, we will take this matter under advisement and issue a written decision in due course as our usual practice.